So I think the first question is that arbitration is an ADR, alternative dispute resolution method, and it is actually much older than litigation. I think arbitration is very natural to our human dispute resolution because arbitration is simply a third party in a sort of non-formal context. You submit your points of dispute to that person, and that person, under some law that you give them, will resolve your disputes. So I think this concept, third-party intervention in an informal setting, is very old. I think all cultures, in all times, could come up with this simple idea that the parties who are disputing with each other, they're so close to the dispute that they themselves cannot resolve the dispute. So you need third-party intervention. I think litigation is a more formal method of third-party intervention. And this came about, it is also a very old method of dispute resolution. But I think the distinction between arbitration and litigation is that litigation now is state-sponsored method of dispute resolution, whereas arbitration is a private method of dispute resolution. Parties have much more control in non-formal dispute resolution methods, whether it is mediation, whether it's direct negotiation. Of course, you have the most control with direct negotiation because there is no third party there. But when you intervene third party into the dispute resolution, it could either be a mediator or a conciliator or a more, like a judge and arbitrator. So I think that is the, gist of arbitration, that it is a third party intervention into the dispute and the resolution of dispute by that third party. Now, more formally, I think the law of arbitration, I would distinguish the law of arbitration in two broad ways. One is the substantive arbitration law, and the other is the procedural arbitration law. Procedural arbitration law would be, well, how do you start an arbitration proceeding? How do you pick an arbitrator? How the hearings are done? How the award is given? How do you enforce the award? This is all procedural arbitration. I think in litigation we have, rules of civil procedure. So similarly, we have rules of arbitration procedure. And then there is substantive arbitration law, which is in the form of statutes and case law. So, and then the third is, in our United States, the unique situation of federation, that we have bi-layered arbitration. We have state arbitration, and then we have federal arbitration. Of course, as I said, most states in the world, about 200, most of them are unitary states, which means they don't have federation. So they don't have this state-federal problem, but we do. And actually, our arbitration law is very complex because of state-federal dichotomy, or because of federation, if you will. So the substantive arbitration law comes from federal statute as well as state statutes. And some of the procedure also comes from the federal and state statute. But I would further explain that why procedure is replaceable, but the substantive procedural law is sort of mandatory. Now, further distinguish these two sets of laws from the law that would govern the dispute. For example, if you have a contract, you I think in most cases you're going to choose a law, and that law would be used in order to resolve the substantive contractual disputes. For example, was there a breach of the contract? What are the remedies available for such a breach? Where do you get this law? I think in most cases, parties choose that law. So clearly we have procedural arbitration law, then we have substantive arbitration law, and then we have choice of law that would govern the contract disputes. Or if it is not a contract dispute, maybe it's a tort dispute, then you need the law of tort. You have to identify the law of tort under which those tort disputes will be resolved. So clearly we are dealing with three distinct kinds of laws when we are doing arbitration: procedural arbitration law, substantive arbitration law, and the substantive law, either tort law or contract law, that would be used to resolve the contract and tort disputes. So in that sense, arbitration law is, three types, and we have to understand each type. I also discussed that nobody can force you to arbitrate your dispute. So in that sense, arbitration is a voluntary choice to resolve a dispute. The default, of course, the default method of dispute resolution is litigation. Actually, under most legal systems, people have a right to access the courts. And increasingly, this is becoming a sort of human right, that the people, both citizens and non-citizens, they should be able to access the official judicial system in order to resolve their disputes. And there, you cannot say, well, I didn't agree to the judicial system, therefore I cannot be brought before the state courts. That argument is unavailable. So the plaintiff has the right to bring you before a state court. Of course, you can go there and say, the case is frivolous, or, even the state court has no jurisdiction, but those are different matters. The plaintiff can bring you to litigation without your consent. But nobody can bring you to arbitration without your consent. So that's the first major distinction, that arbitration is based on agreement, it is based on contract, it is where the parties freely decide that they want to resolve their dispute through arbitration. Arbitration is very good in technical disputes because, as you know, most judges, they are, they have some expertise, but that is mostly legal expertise. They don't have software background, they don't have construction background, they don't have technological background, they don't have architectural background, they don't have background in different trades. So they might not be well equipped to resolve, highly technical disputes belonging to any area of law, any area of, society, but they are experts in law. So I think arbitration provides you with judges who are experts in the area. For example, if you have a construction dispute, your arbitrators could be engineers. If you have a software dispute, your arbitrators could be software engineers who know what the issues are. So they are much more educated in the area of dispute than the regular judges. So I think that is the advantage, that many litigants would not litigate but actually choose arbitration to resolve their disputes, that the technical expertise are available. Of course, even in litigation, you can hire experts who will provide the technical background to the judge, but still the judge is different from the expert. Whereas in the case of arbitration, the expert and the judge become the same person. Historically, I think arbitration was also supposed to be speedier and cheaper than litigation, but I think in some cases arbitration could be very expensive. So I think the cost argument probably is not available in all cases. Arbitration could be very costly. Still, probably arbitration takes less time than litigation. Litigation can go for years, whereas I think arbitration sometimes must be completed in 6 months. So definitely arbitration is a speedier method of dispute resolution. The other important feature of arbitration is that you can custom design what disputes you want to submit to arbitration. So you can determine the scope of arbitration. If you have 10 disputes, you might say we will only submit 5 to arbitration and the other 5 will go to litigation. So you have that freedom not only to go to arbitration but choose which issues will be arbitrated. And you can lay it out in your arbitration agreement. Of course, both parties have to agree to this custom designing of the scope of arbitration. So here we have that, slightly difficult word, which is called arbitrability. And we ask this question, is the dispute arbitrable? And that simply means that does the dispute fall within the scope of the arbitration agreement? And I think if the parties disagree whether the dispute is arbitrable, then the question is, well, who decides arbitrability? And there, the default rule is that the courts will, but you can opt out of that default rule and empower the arbitrator in your arbitration agreement to decide even the issues of arbitrability. So I think not only you can determine the scope of distribution of arbitration, but you can also determine the powers of the arbitrator. I mean, some powers are inherent to the process of arbitration. Arbitration cannot function without those powers. But some powers are not inherent to arbitration, but the parties can confer those powers on the arbitrators. So please distinguish this. That certain powers are intrinsic. They are essential to arbitration. But other powers can be granted to the arbitrators. So arbitrability will again be the issue of whether the dispute is arbitrable, which means that within the scope of arbitration, and whether the arbitrator has the power to decide a given dispute. Now, in the case of the United States, as I said, we have 2 layers. We have the federal layer, we have the 50 states. Each state has its own, arbitration law, Arbitration Act. We studied the Uniform Arbitration Act because increasingly, I think the uniform movement in the United States is trying to minimize variation in areas of law from one state to the other. So even though technically each of the 50 states can have its own arbitration law, but I think for efficiency purposes, Uniform Arbitration Act has been designed so that the arbitration law is the same in every state. Similarly, we have Uniform Commercial Code. So there's a lot of uniform movement of having similar or same laws in each state of the United States. But I think there's a very interesting question here between state and federal dynamics of arbitration. Historically, I think you must have read in your cases that common law was hostile to arbitration. And therefore, in 1925, Congress passed a law to remove that hostility to arbitration. And as I've explained several times, common law was really not hostile to arbitration. Common law was hostile to future clauses of arbitration. I think that point is, should be kept in mind. Common law welcomed arbitration if the arbitration agreement was made after a dispute had already arisen. But common law was very skeptical when the arbitration agreement was made before the arising of a dispute. That's a future arbitration. So common law would, strike down such agreement. But the Federal Arbitration Act in 1925 removed that barrier, and both past disputes and future disputes can be submitted to arbitration by means of a contract. So I think that was the achievement of the Federal Arbitration Act. It removed barriers to future arbitration. But then there were other barriers to arbitration. For example, a state could say that franchise disputes cannot be arbitrated. I think we studied a case where California had mandated that franchise disputes between franchisor and franchisee shall be litigated. Similarly, some states may prohibit arbitration in employment relations, or may prohibit arbitration when a fundamental constitutional right is at stake. For example, right to sexual, harassment, which is that you should not be sexually harassed, or right to discrimination, which means right to not discrimination on the basis of, gender or religion or national origin. So these are so fundamental rights that some states feel that they should be litigated and not arbitrated. So this is a state barrier to arbitration, and I think increasingly federal courts have removed these barriers, opening up the method of arbitration to almost all disputes, including antitrust disputes. So I think in the United States, almost all disputes can be arbitrated. And so we have come a long way from only, limited number of disputes can be arbitrated only if the agreement is made after the dispute has been shaped, to now almost all disputes in all areas of law which may arise in the future. So this tremendous, opening of arbitration. I think you could say, well, why this is happening? Why, arbitration is becoming so open? I think there's so much pressure on the courts. Their dockets are full. The judges are not experts in many areas of society. Commercial interests feel more comfortable arbitrating their disputes because arbitration gives them confidentiality, which may not be available in litigation. So there are a lot of factors why arbitration is wanted by the market as well as by the judiciary. I think judiciary wants to minimize their burden, and the market just likes arbitration as a method of dispute resolution because it provides confidentiality, it provides them with efficiency, with speed, and sometimes even cost. All right. So now, the next question that we discussed was uh, the neutrality of an arbitrator. Of course, a judge must be neutral. I think this is fundamental method of dispute resolution, that the third party who is resolving the dispute should be neutral, because only then the third party can be fair. If the third party is aligned to one or the other party, of course there's going to be a biased judgment, a biased order. So I think it's perfectly common sense and understandable that why an arbitrator should be neutral, independent, and not aligned with any one of the disputants. The United States arbitration law respects this principle, but has a little twist to it. And we discussed that twist. The twist is that if there are three arbitrators, if there's only one arbitrator, then that single arbitrator has to be neutral. But if there are three arbitrators, then I think the United States arbitration law becomes unique from the arbitration laws of other countries. In other countries, all three arbitrators must be neutral. So there's no difference between 1 and 3. Just like 1 is neutral, similarly all 3 should be neutral and not aligned with any party. In the United States, this could happen if the parties want it. If the parties want all 3 arbitrators to be neutral, sure. Then there is no difference between the US and the rest of the world. But if the parties want that the 2 arbitrators should be non-neutral and only 1 neutral, then only the United States arbitration law allows that. Whereas under the arbitration rules of other countries, all 3 should be neutral. So in the United States, each party appointed arbitrator who is non-neutral is presumed to be sort of favoring the party that appointed. Now, of course, even non-neutral arbitrators have certain restraints. For example, they cannot abuse the arbitration proceedings. They cannot be hostile to the witnesses of the other party. So they maintain the integrity of the arbitration proceedings. But everybody knows that when the 3 arbitrators go for private deliberations, only 1 is neutral. And the other 2, are going to advance the arguments and the positions of their respective parties. And we feel that this is totally acceptable. Yes.
I just want to clear up. So, in the United States, you could adopt, obviously, by agreement, that all 3 arbitrators must be neutral.
Yes.
But you're saying in foreign jurisdictions, you can't even adopt the party appointed?
No.
Okay.
I think they
I
are.
was just making sure it didn't
Yes,
go both
I
ways.
think in foreign jurisdictions, they want all arbitrators to be
Okay.
neutral.
So,
And the parties don't have the power to say that the 2 arbitrators would be non-neutral.
okay.
I think this option is available under the US laws.
Okay.
And I think the idea is that in private deliberations, when the 3 arbitrators are sitting resolving the dispute, the neutral arbitrator will get the best feedback. Because he's neutral and the other 2 arbitrators, they are non-neutral, and therefore they're presenting the best case to the neutral arbitrator. Yet they are not lawyers. See, it's a little tricky that you could have lawyers who do the same thing and have only 1 neutral arbitrator. But I think the understanding is that when deliberations are taking place, then the non-neutrals will contribute in ways that the lawyers in the proceedings cannot. And furthermore, the judgment given by the neutral will be fully informed judgment. So I think that distinction should be, even our code of ethics for arbitrators makes that distinction. That the ethical constraints on the neutral arbitrator are different from the ethical constraints on the non-neutral arbitrators. For example, excommunication or ex parte communication. That if you just want to talk to one party and not the other, that's a great breach of neutrality. And a neutral arbitrator cannot do that. A neutral arbitrator must speak to both parties. But a party-appointed non-neutral arbitrator may have, ex parte communication. He may be speaking only to his own party. And ethics will allow that. So I think this is a tremendous sort of unique difference between US arbitration and arbitration in other countries. That we do have the concept of non-neutral arbitrator. So the arbitration proceedings, I think there are certain commonsensical expectations from an arbitration proceeding. For example, very fundamental, very commonsensical, available both in litigation and arbitration, and in any method of dispute resolution, that both parties should be able to present their evidence. I mean, how can you contest this principle? This is such a universal, commonsensical principle that the judge or the arbitrator must give an opportunity to both parties to present their evidence. And if the arbitrator does not allow one party to present the evidence, then hearing is unfair. I think to this extent there is no dispute. All would agree. But when you go into the nitty-gritty of this principle, like all principles, when you look into the principles more deeply, they don't hold up. And that's why we say principles are not absolute. Because there are so many, variation in facts that a principle cannot cover all the facts. And that's why we have rules, which are, more finely conceived to resolve, more precise situations. So principle is a big, idea, and rules are little ideas under that principle. So for example, let's say that the arbitrator says that the hearing will be on such and such day, and one party doesn't show up. The arbitrator postpones the hearing. He, sets another date, sends a notice to the a party that you have not appeared, and we request that you appear on such and such day. The party doesn't respond. There is evidence that the party received the notice from the arbitrator. That's not disputed. But the party doesn't respond, the party doesn't show up. Now what do? Of course their party will not be able to present their evidence to the arbitrator. Now we have two choices at the systemic level. One is that we say arbitration cannot proceed because the principle that both parties should be allowed to present their evidence has not been satisfied. And therefore, arbitration proceedings come to an end. The other option is that the arbitrator says we have tried to get the other party to present their evidence, but they're not coming, despite notice, despite knowledge. And then the other thing is that you go with default proceedings. So the only one party is presenting their evidence. I think we have a similar, situation in litigation as well. And we have a similar concept of default judgment. That despite the notice, despite the opportunity, one party doesn't show up. And the system proceeds and a default judgment is entered in litigation. Similarly, a default judgment will be entered in arbitration proceedings. The only restraint on the arbitrator is that arbitrator is not bound to find for the party that was present and not accept everything that the party wants. The arbitrator may still critically examine the evidence presented by the present party or the party that was present and then decide fairly, what should be done. But of course, a party that is absent from the proceedings takes a big chance that the award will be given against its interests. So the principle that hearing should allow both parties to present their evidence, at the principle level, great, but at the nitty-gritty level, may not be enforceable. All right, so in addition to evidence being presented by both parties, I think the additional constraint is that the arbitrator should be not partial. Because it's very possible that both parties are presenting their evidence, but the arbitrator is partial. The arbitrator gives more opportunity to one party, more time to one party, and less time to the other party. He cuts off their witnesses. He, rules out certain, pieces of evidence from the record. This is not fair hearing. So I think, again, we should have rules which tell the arbitrator that the proceeding should be done and conducted in a fair manner. And there should be no bias, there should be no corruption, there should be even-handedness in terms of listening to both parties. And if the arbitrator is biased, sometimes you can remove that arbitrator. And I will discuss that when I talk about the institutions that provide arbitration services, because they will give you a procedure under which you can remove such a biased arbitrator. Instead of sticking with the arbitrator all the way, you can remove the arbitrator in the middle of the proceedings and have a new one. So that comes to our next topic, which is that when an award is given by an arbitrator and there was something seriously wrong with the proceedings, what can you do? And the answer is that under the procedural arbitration law, you can go to the court and request that the award be vacated or set aside. But the grounds on which you can request the vacating of the award, they are very few. And as you know, that the rules of civil procedure available in litigation are not available in arbitration. The rules of evidence available in litigation are not available in arbitration. Principles of evidence are available. Please make this distinction. Principles of evidence, like fair hearing, like both parties should be able to present their evidence. These are principles of evidence. They are available, but the rules, the precise rules are not available. And therefore, arbitrator is being given the discretion to implement the principles of evidence. Similarly, the arbitrator has been given the power, the authority to implement the principles of civil procedure, but not the rules. And again, one more time, principle is the larger idea, like fair hearing is a procedure, is a principle. But what is fair hearing? There might be so many rules, under the principle. So arbitrator is bound by the principles of evidence, but not by the rules of evidence. Bound by the principles, like due process is a principle of procedure, but there are nitty-gritty rules of due process. And the arbitrator can, design what rules will be applicable to meet the principle. So you can vacate an award or request that the court set aside an award if the arbitrator did not comply with the principles of evidence or principles of procedure. But you cannot request vacating the award if some rules were breached. And I think that's a pretty good distinction, that the arbitrators are bound by principles but not by nitty-gritty rules. So corruption of the arbitrator, clearly a ground for vacating the award. If the arbitrator is evidently partial during the proceedings and you have to show that, yes, the award can be vacated. All right. So I think I've been saying that arbitration law is procedural as well as substantive. Now, what do I mean by procedural arbitration? Procedural arbitration law means that how do you start an arbitration proceeding? There should be some procedure. For example, in litigation, you file a petition with the court or a complaint with the court, and then the defendant is notified, the process is served on the defendant, and the defendant replies, and the process begins. Similarly, we need procedure in arbitration. And where is that procedure coming from? I would say that procedure comes from either a statute or from the rules of an institution. Please note this point. There are two sources of procedural arbitration law. One is the state statute, and the other is the institutional rules if the parties have chosen the services of an institution. One more point, that how do we know that which statute would apply? Because there could be more than one statute or procedure, arbitration procedure, like we have federal arbitration law and state arbitration law. Both have procedures. How do the parties know? Well, I think there we have, question of federal jurisdiction. That how do you go to a federal court? For example, if the litigants have diversity of citizenship, then you can go to a federal court. And if you go to the federal court, they're going to apply the federal procedure of arbitration. If you go to the state court, then the state procedure of arbitration is going to apply. But both procedures can be opted out of by choosing the rules of an institution. What do you mean institution? As I said, in my, during the semester, there are 3 or 4 prominent service providers, institutions that provide arbitration services. In the United States, we have AAA, American Arbitration association. Internationally, we have International Chamber of Commerce. We have London Court of International Arbitration. We have the rules of United Nations Commission on International Trade. So these are all institutions that provide procedural rules. And they will tell you how to pick an arbitrator. These rules will tell you how to file, how to start an arbitration. These rules will tell you how to respond to an arbitration request. These procedures will tell you how the hearings will be done. These procedures will tell you what you can demand in a hearing. These procedures will tell you that whether the award is going to be in writing, whether the arbitrator will give reasons for the award. So all these procedures will be, will be coded in the rules of the institution. So your life becomes much easier if you accept the rules of an institution, because they have thought about every possible scenario which can go wrong to an arbitration, with an arbitration proceeding, and they have a solution for that. So I think that's why the rules of an institution are much more useful than the state statute. I think the state statute covers the minimum procedure possible. I think they probably will tell you if you cannot appoint an arbitrator, then how do you solve that problem? But the nitty-gritty procedure is given in the institutional rules. So that's why even if you don't hire the services of the institution, you can nevertheless subscribe to the rules and then choose some other arbitrator and ask them to follow the rules of the institution. That is possible too. So it's not that you can use those rules only if you take the services of that institution. There's no necessary link between the two. So I think one point that we discussed was that what if there's a procedure in the state statute and then there's a procedure in the institutional rules, and the two procedures are incompatible? Then what do you do? I think then you ask the question whether the statutory procedure is mandatory or optional. If it is mandatory, you have to comply with it. If it is optional, then the institutional rules will preempt the state procedure, because institutional rules reflect your agreement. So here a contract rule will replace an optional statutory rule. And I think this point needs a little bit of understanding, but it's very easy to understand that all rules given by a state statute are not mandatory. And if you can vary from them, then you can vary from them either deliberately or by accepting the rules of an institution, which give you a contrary rule. For example, suppose the state statute says that it is the court that would decide whether the arbitration agreement exists. That this is so fundamental to arbitration, because arbitration cannot proceed unless there's an arbitration agreement. So if the parties disagree over the existence of the arbitration agreement, then the parties can go to the court to settle this preliminary issue. And if the court says, yes, there's an arbitration agreement, they go to arbitration. And if the court says there is no arbitration agreement, they litigate. Now, this is a pretty clear rule. But the question is it a mandatory rule or is it a default rule? If it is a mandatory rule, then the parties, if they don't agree on the existence of the arbitration agreement, they will have to go to the court. If it is an optional, if it is a default rule of the statute, which means that the parties can agree otherwise. If they don't agree otherwise, then the court will have jurisdiction. But if they agree otherwise, then they can give this power to the arbitrator. That the arbitrator will decide whether there is an arbitration agreement. So the proceedings will begin, arbitrator will be appointed, the proceedings will begin, and then the first question will be that the parties disagree over the existence of the arbitration agreement. Well, a lot of institutions give this power to the arbitrator. So now we have a state statute which says we have a default rule for you that if you disagree over the existence of the arbitration agreement, go to the court. The institutional rule says you will have to go to the arbitrator. Right? Now parties have chosen the institutional rules. So they have given up the optional statutory rule. And now they must submit the issue of whether the arbitration agreement exists to the arbitrator. So I think that's a classical, explanation of a mandatory statutory rule and a default statutory rule, a waivable statutory rule, a non-waivable statutory rule.
I was just gonna ask, all you really need to do is say that you've adopted the institutional rules, and then those rules basically preempt any default statutory
Exactly,
rule.
right.
You
You don't have to, go item by item.
Yeah, but could you limit the institutional rules that you adopt? Could you
Okay,
say-
now that raises another question. Whether the institutional rule is default or mandatory.
So it goes back the same way?
It goes back the same way. Some institutions may not allow you to vary their rules. So once you accept their rules, you're bound by them. But if they give you the option to opt out, then you can.
Okay.
Because ultimately the parties decide how they're gonna resolve their dispute under what arbitration rules. So I think the institutions will give you a ready-made rules that, okay, here are the rules. Most reasonable parties would accept these rules. So look at them, if you wanna change some rule, maybe we'll allow you to change. And some institutions will say, well, take it or leave it. If you want arbitration proceedings to be done under these rules, that these rules cannot be varied from. But we do know that the statutes do have, we studied that, the Uniform Arbitration Act, it very clearly indicates that which rules are waivable and which rules are non-waivable. And I think that is a very important section of the Uniform Arbitration Act. So if there is a incompatibility between institutional rule and statutory rule, first you will look up a section on waivability and see if the rule is waivable. And then I think that will solve the problem. All right, I think one more point, and that will be on international arbitration. Now, distinguish between domestic arbitration and international arbitration. International arbitration is when one of the parties is from a different country. Or other way, when two parties belong to two different nation states. And they have a dispute, and this will be a dispute internationally in character. So international doesn't mean that there's a state, nation-state party to a dispute. There could also be an international dispute. For example, a lot of investment disputes could be between a corporation and a state. And they might want to submit their dispute to arbitration. But that's different. That's state versus national, or state versus person. Whereas we are talking about two persons, whether two natural persons, or two corporations, or a corporation and natural person. If they have a dispute and they resolve their dispute, this will be an international dispute. And I think this could be very complex because the place of arbitration could be one and the enforcement jurisdiction could be another. And that's why we have the New York Convention on the enforcement of arbitration awards. Suppose the arbitration award is given in Germany, but the defendant's property is located in the United States and nowhere else. And the defendant is not complying with the award. What do? If you are the award holder, if you are the plaintiff who has won the award, you're going to come to the United States, go to some court, mostly a federal court, and try to enforce the award. And New York Convention mandates the signatory states to enforce foreign awards which were given in another state. That is the whole purpose of New York Convention. I think I mentioned that we don't have a similar treaty on the enforcement of foreign judgments. So if you have a judgment from Egypt, a money judgment, and you want to enforce it in the United States, there is no treaty. But if you have an award given in Egypt, you can enforce it in the United States because both Egypt and the United States are signatory states to the New York Convention. Well, I'm not sure if Egypt is, but suppose Egypt is. Then I think it'll be very easy for you to go to the U.S. court and have the award enforced. Of course, if you want to set aside the award, you have to go to Egypt. Please make this distinction. Setting aside an award is not the same thing as non-enforcement of the award. That's why the place of arbitration is critical. Because the law of the place of arbitration will decide whether an arbitration can be set aside or vacated. So in our example, if the place of arbitration was Egypt, then the procedural law of arbitration of Egypt will apply. Because that is the place of arbitration. And if you want to set aside the award given in Egypt, you will have to use the Egyptian arbitration statute. And you have to go to the Egyptian court to set it aside. But if you want to enforce it in the United States, then the United States court cannot set it aside, but it can say we can't enforce it. So refusal to enforce is not the same thing as setting it aside. If you want to vacate the award, go to the place where award is given. Because where the award is being enforced, that jurisdiction does not have the power to vacate the award.
I get the distinction, but at the end of the day, it's either way, it's not being enforced, right?
No, because if the United States refuses and the defendant has property in Germany, now you can go to the Germany to get it enforced. So if it has not been set aside, then you can go into more than one jurisdiction to get it enforced. But if it has been set aside, it cannot be enforced anywhere. So that's the distinction. And I think our time is up, and thank you very much. That's all I have for the review.